Let's bring in Nick Freeman now. Nick is a motoring lawyer, also known as Mr. Loophole. Morning to you, Nick.
Morning, Sonia.
Morning. What do you think about this expansion of the ULEZ zone?
Well, it's a very interesting proposition. I'm not going to argue against the merits in terms of having clean air. I think we all want clean air, but that's quite a complex issue. But looking at it from a legal perspective, I'm not sure whether your area is going to have signs or not, or has already had the signs put in place. If it hasn't, there may well be a problem from an enforceability perspective. And I'm not trying to tell your the residents in your area that they can get in their car and drive, but certainly, so far as the law is concerned, it looks like that without the right signage, which has to be authorised and it has to indicate there's going to be a charge, um, it's basically unenforceable. And I know that sounds quite unpalatable, and you'll be astonished to hear that, particularly as this has been coming up for some time. There was a case in October 2021, and this was in central London. And although it's not a binding case, in my view, the adjudicator got the law right. Um, and it concerned a gentleman who got £11,500 worth of tickets. The adjudicator considered the case, and this was in central London where there is signage. And he ruled, number one, that the signage was not authorised in relation to the relevant provisions. And more pertinently, the signage that did exist didn't warn motorists that you were actually going to be charged. All it said was you're entering a ULEZ zone, an LEZ zone, and it has
Yeah.
to provide more than that. And the point is, I mean, you see it with Dartford, you see it on congestion, you see the signs, and you see a C there, a white C and a red background, which tells the driver you're not only just entering this area, but actually there's a consequence. And the purpose of these signs is obviously it's just to provide sufficient information so that the motorist can make an informed decision. So the law at the moment appears to be in central London, the signage there is inadequate and unenforceable. So if you come out of that area and you're dealing, I think, with 6 out of 7 boroughs where you're saying we're not actually going to even put the signs up, I think there will be a huge problem in terms of enforceability. And I say I'm not telling your drivers they're not going to have a problem because there is the infrastructure already in place to issue fines if people drive into the area. And then, of course, the motorist has the problem of appealing to TfL, and we know what stance they're going to take. And then, of course, the motorist has to go to the adjudicator. And it's a case of whether the motorist wants to embark on that course or whether, in fact, the motorist decides I'm just not going to have that degree of aggravation. But legally, my view is that there's no signs, therefore it's unenforceable, and the signs that currently exist don't meet the legal requirements.
Gosh, so how many appeals do you think TfL are going to receive from motorists? This sounds like, as you've sort of touched on here, this is opening up a lot of potential people saying, well, I'm not going to pay, and here's the reasons why.
Yes, look, look. In the last 2 years in central London, there's been £320 million worth of revenue from fines and people who have paid, and this relates to people, not only people who have been fined, but also people who have paid voluntarily, because you can't pay voluntarily for an area which actually doesn't have the adequate signage because it's not actually fit for purpose so far as the law is concerned. So I can't really believe we're having this conversation. It's astonishing. Um, but ULEZ, TfL were questioned about it when they were spoken to about this recently. They said, "Oh, we've won the appeal," and they knew the case. They said, "We won it." So that they were asked for the copy of the appeal, and they said, "Oh, can we come back to you Tuesday?" That's today at lunchtime. Then they said, "Well, actually, we've looked at our papers, and we're quite confident in what we've said." So it's the most bizarre situation, and it just doesn't make any sense. It's almost surreal, isn't it, that you've got an area covering millions and millions of drivers. This has been blowing up now for some time. There's been massive publicity about it. The point isn't, do motorists know about it? Have they heard about it? The point is quite simply legally, are the signs in place? Are those signs authorised? Do they provide sufficient information? If they do, absolutely, then all motorists definitely have to comply. At the moment, there's a huge question mark. And if I was advising TfL, I would say to them now, announce that actually the scheme is going to be put on ice. We're going to review it. We're going to make sure the signs are put up, and we're going to make sure that the signs provide sufficient information to tell the motorist not only they're entering a zone, but there is a charge as a consequence of that.
And you would suggest the signs would need to really go just outside of the zone as well to warn people that it's coming up? Because, I mean, that's where
Yes, there has to
Essex
be.
comes into
Yeah,
play with that.
there has to be warnings not just in the zone, but they have to be warned outside that they're approaching a zone, so they're not being ambushed. You don't want to be in a situation where, oh, I'm in a zone, I can't afford to pay. You have to be warned in advance you're about to enter a zone, or there's a zone half a mile further up the road, as they do with congestion, as they
Yeah,
do with the Dartford charge. It's
yeah.
exactly the same thing. And the point is, it's fair. The motorist can make an informed choice. The motorist knows there is a consequence. If I drive here, this is where I'm going, this is what it's called, it's authorized, and this is the consequence. I'm going to have to pay. And obviously, there's different times and things with ULEZ. It's all the time, so they don't need to notify a time. All they need to notify, in my view, is that it's a charging area, which just basically involves putting that C on the board to tell people that it's actually a charging zone. That, in my view, will be sufficient. But they also have to get authorization. And at the moment, what happened in this case was the adjudicator was so shocked by by the way the case was presented that he actually adjourned it for 3 weeks for TfL to produce the information to prove to him that the signage was authorized, and they didn't do that. And
Gosh.
he also gave them that opportunity to show that it provided sufficient information. And again, they didn't do so. They did absolutely nothing during that 3 week period. Now, this is a hearing at first instance. This is an adjudicator's decision, so it doesn't create a binding precedent. In legal terms, it's persuasive. So anyone can refer to that case, and in my view, the adjudicator's got the law right. The provisions, some of the provisions, they're contained in 488 pages of regulations. But the part that relates to this particular section is quite straightforward, and it just makes absolute sense. It's not complex law. You have to prove it's authorised, and you have to explain the consequence.
Yeah, and also, I suppose, make sure people have adequate notice so they can avoid that charging area if they don't want to go into that charging area. I've got to leave it there because I've got to do the travel. But Nick, thank you for coming on. Motoring lawyer Nick Freeman on BBC Essex.